That concludes the amendments. I would like to conclude my remarks and note that this past Friday, I received a letter from the Georgia Chief of Police Association. That's one of my chiefs back here. And they have offered their support as the bill stands for HB1. So with that, and I believe the state attorney, I want to ask the state attorneys if they can come forward. Who we have here? Mr. Porter.
Mr. Chairman.
There was a couple of things they raised, and I need to talk to them if there's a need to be amendments. Some of it was just not clear to us. I haven't had a chance to draw these up last Friday to speak with them, but let them talk to themselves if they'd like to issue.
Thank you, Mr. Chairman. Members of the committee, last Tuesday before the snow apocalypse, or whatever they call it, we were in receipt of LC 295757S, which was the beginning of the process of HB1 and the substitute for HB1, which we testified in favor of in general. And we were able to analyze that bill, and we made some suggestions that we delivered to Chairman Jacobs and to Chairman Willard, and some of those have been incorporated in the amendments that you have before you today. And I'd like to very briefly go over those, and then there are a couple that we would actually like to discuss with you in terms of our suggested amendments to move this bill forward. First of all, in one of the amendments in the discovery provision, I believe it was the fourth amendment discussed by Chairman Willard, it revised lines 407 through 413, and we would note that the same revision needs to be made at lines 451 through 457 using the same language.
It is. I didn't go into. I'm sorry.
Yes,
it does. Understood. It does address both of them.
Okay.
I'm mistaken.
Thank you, Mr. Chairman. And we haven't seen the amendment, so I wanted to be reminded for that. We wanted to thank you for the changes to the innocent owner, which is the amendment to line 555. And we wanted to thank you for the changes to lines 641 through 642, which were the changes to the language regarding distribution of in-kind income, and also the idea of removing non-law enforcement entities from the reporting requirement, since those agencies would not have the information that was necessary to make these changes. We would make a couple of suggestions in terms of, one is a policy, and frankly, I realized that we had not really thought about this until as we were going through the changes, but frankly, it seems like a decent idea, is that if you look, we would suggest a change after line 633 and before line 644. And it is, we have the language that we can prepare to the subcommittee, but essentially what we suggest is the ability for the court to order that lights and equipment for plant growth forfeited to the state can be donated to educational institutions. We in Gwinnett have had a tremendous problem with grow house cases. We knocked off 20 of them, I think. And all of a sudden you've got thousands and thousands of dollars seized that are very expensive hydroponic growing equipment that if you sell it as required by statute, by the forfeiture statute, you sell it back to dope growers. So we did it by court order, unknowingly. We distributed to Gwinnett Tech for their horticulture department, and we gave thousands and thousands of dollars to that. And this seems like a good policy idea as a use for forfeiture, and this is part of our suggestions in the outline.
May I respond? This was one of the things that did bring to us. I believe in the bill, the state attorneys or law enforcement agents have the capacity to make that determination and give it to another state agency. That's what we're talking about, the state agency.
Actually, Mr. Chairman, specifically, you can only give it in kind. You can only make an in-kind contribution or a cash contribution.
Yes.
This would clarify the ability to give specific items to specific organizations.
Is that not in kind?
It is in a sense, except that it's used up, it's used up by the university and on a continuing basis, whereas in-kind is more along the lines of a car or something that's used for official duties.
May I suggest, let me sit down with you and talk about it. I'm not opposed to it at all. We're in agreement. It's just I think it is already included as a means of doing this. If it's not, we want to get it straight. That
Yes.
it is.
And
Now,
of
what I
course,
suggest is we don't want to maybe identify a specific type of property that may be acquired through forfeiture, but just the property itself.
yes.
That's my question is, Danny, if you set one thing, then you're gonna have other things at some point. I've been there where you are, you know I have.
Yes.
And you're gonna have other things you're gonna want to do. So I agree with the chairman, let's don't confine it to an item, but items of that nature. I think you can work out some terminology on.
And we're perfectly happy with that because we believe that we should be able to transfer some of these items
Right.
in kind to
But see,
educational
if you name one,
institutions
you
and-
can only do it.
Yes.
Okay.
The net,
Sure, Ms. Travis.
The location for that would not go there. We're gonna, if it's his disposal of property, so it would go in another location.
We'll be glad to work on it, Mr. Chairman. We would much rather see it brought in the barrel.
the next suggestion we would make, Mr. Chairman, is a revision of lines 770 through 847, which was included in at least one of your amendments, but we have submitted a more complete requirement of the reporting that's going to, and that's going to be done to the Carl Vinson Institute. And what we have done is identify, in particular, the distinctions between the law enforcement reports and the prosecuting attorneys' reports that are made. Also, I believe one of the things that was suggested in the earlier committee meeting is contained on one of our suggestions where we talked about the dollar-for-dollar accounting of currency, and this would allow for an accounting process that allows for end of year in, end of year out, and compared with expenditures, and that's the language that we're suggesting.
It gave me some pause in reading it because I felt like the language that you were suggesting was not going into giving the details of what was acquired and then what is used. Maybe I'm wrong, but if there's something wrong, the main thing I want to be sure is that we know we'll have, talking about cash now, cash coming in.
Yes.
We'll have cash expenditures, we'll have a cash balance.
Yes,
And that goes from year to year.
yes,
And I want to be sure that we talk about it on that basis. Cash in this year, the specific forfeiture that was involved by which you acquired the cash, and then a listing of all the things that may have been used of the cash for expenditures, and then you have your balance.
Yes.
This is like a regular accounting, ledger accounting.
yes, sir. And if you'll look at our suggested amendments, it begins with section 3B, little I, and it gives it requires the amount of currency and the date of the currency was received by the entity in accordance with an order of distribution, the statute or statutes upon which the currency was subject to forfeiture, and then it goes on to talk about the total for the reporting year of the amount of currency forfeited, net income from the sale of forfeited property which the entity received for official law enforcement purposes, and then a 4, or IV, small IV, is a description of the use and expenditure of forfeited currency and the income from the sale of forfeited property for the reporting year, specifying each expenditure, the amount expended, and the official law enforcement purpose for which the expenditure was made. And the reason we ask for this separation between law enforcement and district attorneys is because not only are the reporting requirements different somewhat, but more importantly, the disbursement mechanism is completely different. And so we think it's important within the disbursement portion of the statute to differentiate between law enforcement and district attorney.
Would you describe for us then what you see as the distinction or difference you would have in the reporting requirements for law enforcement receiving cash as opposed to state attorney receiving
Well,
cash?
first of all, the law enforcement The law enforcement, and first of all, law enforcement agencies and multi-jurisdictional drug task forces, the annual report shall include but not be limited to the following information: the date the property was received by the entity in accordance with the order of distribution, make, model, and serial number when relevant. Those are in-kind contributions, and then forfeited. I'm sorry, Mr. Chairman. And then in regard to district attorneys, the amount, I've just read to you the law enforcement. It says the amount and the date the funds were received. It does not require. It does not require. It does not require the source or the type of. And then for district attorneys, it says that the description. I'm sorry, I'm losing my place here. The amount and date the funds were received, and a description of the use to which the funds were put in accordance with 15-1848 F1, provided, however, that such details will not be required, and such details, when closed, would disclose the identity of a confidential investigation. Then it goes on to say the total amount of funds on deposit with the financial institution, the annual report required by this subsection, and then the district attorney has jurisdiction. We need to talk a little bit about that. But the differences between the DA's report and the law enforcement report is that the law enforcement report has to talk about the origin of the seizure. Since we get 10% of the seizure, we're not as concerned about the origin or the crime which gave rise to the seizure, as long as there's an order of distribution. And that's, we're more concerned with the expenditures through the district attorney's trust fund. And that's the reason we suggested that.
Let's do this talking outside the room. We'll see if we can resolve that.
Finally, Mr. Chairman, the last section that we suggested is that the bill as written says that the Attorney General will have the authority to conduct any investigation and bring any civil or criminal action he or she deems necessary to ensure compliance with the provisions of this subsection. We are suggesting that the district attorney having jurisdiction over the local law enforcement agency or multi-jurisdictional drug task force be authorized to conduct the investigation unless there is a conflict.
This is 825, Section 5 of the committee.
Section 825, Section 5.
Yes.
And also, we would ask that the code section says that if there are found a violation of the subsection within 30 days, we would ask that be extended to 60, because it may not be possible to complete that investigation within 30 days.
I think from policy standpoint, speaking personally, I would want to leave it with the Attorney General. I think that there's purpose to have oversight from the state level as to these type of investigations if they do involve either criminal or civil compliance with what the law requires. And I think it's, frankly, more comfortable. I think the local DAs, if they don't have to worry about it, there'll be that type of investigation. The people you're dealing with on a day-to-day basis may be involved in law enforcement agencies.
Mr. Chairman, I hear you, and we've disagreed before, and I'm going to have to respectfully disagree. I don't mind. You know me well enough. I don't mind investigating people who sit next to me at the meetings. And I think that
If I knew all 49,
yes, sir.
had
And
the same approach.
I think that this is an expansion of the original jurisdiction of the Attorney General that is not contemplated by the Constitution or by the Code, and I think to deprive district attorneys of at least the first opportunity to conduct these investigations, particularly when there's not a conflict, is to say something about the district attorneys of the state that we would prefer not to say. And I think that this expands the jurisdiction of the Attorney General indirectly into an area that is the province of the district attorney, and that is our position on that aspect.
Yes.
Any further questions for Ms. Porter or prosecuting attorneys? Seeing none, thank you for, and the reporting requirement, especially conflict.
Yes.
Chairman.
Mr. Chairman, can I be excused? I've got to go to Chairman Pack's bill or committee.
Certainly, and as I've said, we're going to take this bill up in another subcommittee hearing with a scheduled vote later on in the week, so. Thank you. Mr. Rotondo, do you want to say anything?
Well, I would. I'd like to say that.
Sure.
Thank you. My name's Frank.
And bring your chief with you.
Thank you. Well, let me tell you, first of all, I'm Frank Vincent Rotondo, and I'm the Executive Director of Police Chiefs for Georgia. I've been watching HB1 since its introduction as a pre-filed bill. Chief Billy Grogan is with me. He's the Police Chief of Dunwoody, Georgia. He's also here because he's a member of our Executive Board. We've watched the bill grow. We watched the committee, not necessarily this committee per se, but the committee that met during off-hour time, off legislative hour times, to hone this bill. Very comfortable with the bill. It went through a vetting process in our association more fully than when we originally met last week, because everybody has now had time to look at that LC number. Very comfortably, the president, with the full endorsement of the board members who participated in that conversation, agree that this bill is very good, very well done, and it safeguards the interest of law enforcement in general, and it's fair to the public.
Does anybody have any questions for Mr. Rotondo? Seeing none, thank you for
Would
that.
you-
Chief Grogan, do you have anything to add?
No, I just would like to
Good to see
say.
you, by the way.
Good to see you. Appreciate Chairman Willard being able to work with us during the off legislative session, and you, sir, to get this bill in a position that we can certainly support. We appreciate it.
Thank you. Does anyone else want to speak on House Bill 1? Yes, in the back. Ah,
Mr. Chairman,
good to see you.
Mr. Chairman, Terry Norris with Georgia Sheriff's Association. Just a quick comment. I wrote you a little note, Mr. Chairman Willard, last week. Sheriffs remain opposed to the substitute of House Bill 1, although there is some dialogue in our future, I understand. The sheriffs believe that this bill unnecessarily complicates one of the greatest crime-fighting bills, laws in our state's history. We believe, though, that this committee did do some really good things concerning burden of proof, the $25,000 threshold on quasi-administrative hearings, and, of course, the discretion for the use. But as I said, Mr. Chairman, I'm not here to be adversarial today, but we are going to have a dialogue, I hope, Mr. Chairman Willard, tomorrow on some issues. And just for the record, I want you to know the sheriffs have not changed their position on this bill at this time.
Well, that's unfortunate because it's a good bill, but I do appreciate that you're continuing to dialogue with Chairman Willard. Any questions on that? Seeing none? And obviously, you
Yes,
know our timetable, we're looking
Yes,
toward the
yes.
end of the week, so
Thank you.
next couple of days with Chairman Willard.
Yes, sir.
All right, anybody else want to speak on House Bill 1? Seeing none, and Judge Osborne's gone, I forgot to introduce him. All right, sorry. Judge Samuel Osborne was here with us as well from the Ocoee Judicial Circuit, correct? Superior Court Judge. Unfortunately, I guess he went on to the PAC subcommittee. Actually, he went on to the Senate. Oh, all right. Visiting with the Senate, so just wanted to recognize him. All right, being that there's no more testimony to be given on House Bill 1, we'll go ahead and close off discussion. The bill, like I said, will be on an agenda toward the end of the week for a subcommittee vote, and certainly bring any remaining concerns to Chairman Willard between now and then.